The reason why we thought that this discussion might be interesting here in Hungary with our international guests is the fact that the level of the discussion so far is very political, and political parties are debating about this negotiation and this treaty, and we have the mission and we have the target of raising the professional level of the discussion around this very complicated and very technical debate and technical treaty, which is actually affecting the life of most of us. The other fact that called us to organize this debate is the fact that the European Parliament is going to have a resolution on TTIP expressing its opinion about the process, about the economic consequences, and about the whole legal framework. So the reason why we have our panelists here, and shortly I will introduce them to you, is that we would like to have a political overview and a political picture about the negotiation and the relationship between the USA and the EU at the moment. And we would like to know a little bit more about the ISDS, which is the most controversial fact and part of the whole negotiation and the whole process. And of course, what is the most interesting is that we would like to know what kind of economic effects are going to come in case this treaty is accepted, or in case this agreement is accepted. So we have our dear guest, and thank you very much for accepting the invitation of the institution. Tamás Meserics is member of the European Parliament and member of the Committee on Foreign Affairs, and he's going to be able to give us a picture of the resolution on the construction, and going to be able to give us a picture of the political weight and the political aspects of this negotiation. Dr. Professor Schepel, sitting on the other side of the table, then will help us understanding what ISDS is and how controversial that is. We'll be able to explain us in detail the arguments against and, well, the little arguments in favor of ISDS. And dear audience, you will have the chance to raise your questions afterwards. So please be prepared with the question, because this is the opportunity when we had experts at the table. And Dr. Werner Raza is one of the experts who wrote a detailed study and assessment about ISDS with the title of Assessing the Claimed Benefits of the Transatlantic Trade and Investment Partnership. So we have a person here at the table who examined and assessed in detail this negotiation and this treaty. So please prepare your questions, and I would like to give the floor to Mr. Tamás Meserics.
Thank you very much for the introduction, and allow me to start with my thanks for the institution for organizing this. Not just because this is topical and this is important, it is true, but as Katalin has already mentioned, because I really think that a crucial set of professional assessments are still missing, not just necessarily from what public opinion knows about this, or the voters in general know about this, but even in specialist circles, there is a large set of open questions for which there might or might not be answers. That's a further issue. Now, I am in the lucky position for not being an expert in any of this, so I have the chance to put forward the unenlightened thoughts of somebody who is responsible for voting about this at the end of the day. But the point I would like to make with this is that if I'm in a position in which I do not understand a number of crucial issues, and I know that I'm in that position, and I was looking actively for that information, then there is a problem. If I don't know what the elements are, what the important elements are, and how they fare in international private law, for example, or in general macroeconomic terms about the effect, then there is a problem. And Of course, there are other members of the European Parliament who might have much more information in other committees, in ITRE, for example. Unfortunately, none of the Hungarian MEPs are at the hub of this. So that's why I'm taking this up, not because I'm aspiring to become an expert on TTIP, but because somebody has to do it. And I could be sort of understood here as a representative sample of the European Parliament. I don't think I know much more than the average member of the European Parliament about TTIP, but I'm heavily invested in trying to find out, and I had problems. And this is where I would like to start. Although I'm very grateful for having this opportunity and sort of lifting some of the veil on the details of the TTIP, and this is partly due to the Commission's efforts to increase the transparency and visibility of the whole process, nevertheless the process remains hopelessly untransparent from a point of view even of an ordinary MEP. You may know or may not know that MEPs are entitled to see some of the details of the negotiations in a closed research room with no possibility of taking notes whatsoever of any kind. So, I mean, next time I'll develop my memory skills for getting some of the information stored. And at the same time, we don't have access to files which some other members may have access to. For example, members of the ITRE committee have a larger set of files available than we do. Still, officially, the Commission has never admitted that there are consolidated texts on TTIP. Consolidated text means that those parts which have been negotiated and basically agreed upon by both sides, which are just waiting for finalization in technical terms, but the core is there. We know from rumors that there are consolidated chapters, but not just not seeing it, the Commission has never even admitted that there are consolidated chapters. And that is also worrying. Not that I would like to suggest that all trade negotiations from day one to the very end should be completely open to all concerned, because that undermines some of the aims of negotiations. Some of it need to be negotiated with the knowledge that what we are talking about now is not going to go out tomorrow, but after a due process of both sides evaluating the results. So I'm fine with some limitations on the openness of these negotiations. I don't want to claim that it should be necessarily open in the sense that these negotiations should be, for example, streamed on a website while they're going on. That would be possibly self-defeating. But compared to what is going on now, this is not even a minimum of transparency that surrounds this. However, we happen to know that there is very little time for the negotiators to complete basically all the basic chapters, for the simple political reason, and this is a very trivial calculation that all of us, I suppose, know, that if there are no fully negotiated consolidated text by the end of this year, by the end of December 2015, then there is not going to be a finalized treaty anywhere near before 2018, for the very simple reason that in 2016 there will be American presidential election, in 2017 there will be French and German general elections. And possibly nobody would want to enter into an electoral campaign with a half-negotiated treaty. So if there is no agreement by the end of this year, then this will be postponed by at least 2.5 years, as much as we know now. And that is also in some sense worrying, because we just don't know how much of the negotiations is still to be done on the very basics, one of them being ISDS. We are going to get into some of the details with that, but of course the problem from our point of view as regulators, as members of the European Parliament, is not necessarily simply a question of sovereignty. It touches upon the issue of sovereignty, but it's a more general problem with regulatory power. It's not just, it's whoever is the regulating agency, it doesn't matter. ISDS tends to undermine the regulatory power of whoever the regulatory agency is then, be it a local government, be it a national government, be it the European Union as such. So the issue is not just a trivial issue of state sovereignty, which is already an old concept, and so on and so forth, and international private law and the conflict between the two. That is a traditional story. But this is more about regulatory power at whichever level we understand regulatory power. And finally, and I hope we'll be able to touch upon that, although there are various projections and assessments about growth-inducing possibilities with the TTIP, what we are crucially lacking at this point is the differentiated effects of this. An overall close to one percentage point extra growth in the European Union might actually mean negative growth in some areas and the larger growth in some other areas. This is, even in the terms of assessment, is an average growth rate. And we know close to nothing about either the sectoral differences or the regional differences, and that is something which needs to be taken into consideration before anybody can take an informed and honest decision on this. So thank you very much. This was my way of a political introduction.
I would like to extend this political introduction, because we still have 5 minutes from your time. So I just ask one question before we go on.
I'm sorry, I got used to the European Parliament speed, where you have 90 minutes, 90 seconds at most. I'm sorry about that.
So we do know that this negotiation entered somehow the field of foreign policy and foreign politics, because at the beginning it was clearly about job creation, clearly about boosting economics on both sides of the Atlantics, and eventually at the end we just realized that, well, people who are engaged in foreign politics are starting to talk about it. So why did it go up from one level to another level? What is the reason? Why is it so important? And what changed in the last half or 1 year in that case? And I would really like to have your point of view on the on the debate that we have in the European Parliament and what we have in the USA, because both countries are split. So it's not the fact that one side is very much into it and the other side is, well, kind of pulling itself out, but both continents are split in this question. And what are the pros and cons on both continents?
Yeah, I would have spared some of that for the end, but of course I have no problem with this one. The reason why, the topic has been upgraded, so to speak, is because even a partial opening of the negotiations and the first information coming out made a large number of ordinary European citizens realize that this is something very important for them, their individual lives and their livelihoods might be at stake. Originally, this was not introduced as something which will have an effect on the everyday lives of European voters, but as the information gets out, of course, people realize that it tends to be important what the negotiating parties agree to at the end. So one of the reasons is simply pressure from voters, mostly in Western Europe. Again, that is not surprising. There is more experience with these types of trade regimes and negotiations and the results of them in Western Europe. There is more expertise in the area, and actually information filters through much easier in much of Western Europe than in the eastern part. So that's one of the reasons. The second reason, obviously, is that this became politicized in fundamentally geopolitical terms. Whether that is good or bad is very difficult to assess. I'm usually against raising the stakes of trade negotiations with claims about geopolitical significance. But sometimes it is unavoidable, it is done whether anybody intends it or not. Nevertheless, it is in one sense harmful because geopolitical significance is usually used as a trump card over details of the results. Finally, about the splits, of course there are splits according to party affiliation in the European Parliament, in national parliaments, but what is more important is that the split in Europe is more significant and I think more even than what we know about political opinion about this in the United States. One of the reasons might be, but I might be wrong on that, so this is more of a question than a statement, that the regional differentiated effects on the United States would be different. There would be regions which would clearly gain from it, but there would be very few who would stand to lose from an agreement of this sort. Whereas I believe in Europe the situation is different. There might be regions which tend to gain from it, but there might be regions which tend to lose out from it, and may even be significantly losing out from it, depending on, for example, the sectoral effects. So this is in a nutshell why I think it's going to be a high priority public debate and remain as a high priority public debate in Europe, but I don't expect it to be a high priority public debate in the United States for the time being. Of course, if the negotiations stall, then it's a different story. It's anybody's guess who is going to use it in what terms in their political campaigns.
Yes, well, thank you very much. So we will see how the procedure goes on in the next 1 year, at least. This is what we see so far. And the most controversial part of the debate in the European Parliament and in the international papers as well is the ISDS. So now we will have the chance from Professor Schepel, from who's a professor of economic law at the University of Kent and the director of law programs at Brussels Schools of International Studies, to actually learn what ISDS is and learn how it affects our judicial system and how it interferes with international law and EU law. So please, Professor.
It's going to ask me in Hungarian to start a slide. Well, thank you very much. It's an honor and a privilege to be here. I hope I'll be able to explain the intricacies of investor-state dispute settlement, or ISDS, but do please interrupt or otherwise ask questions afterwards. And so I think the first thing to do is to understand a bit the current system of international investment law as it exists, and it does exist in over 3,000 bilateral investment treaties globally. These 3,000 treaties are nominally different, but in fact they're not extremely different. They are, for one thing, most of them model treaties by large states. And they reproduce much of the same provisions and doctrines that they within the system. And so, by and large, there are two things that happen in these investment treaties. One is these treaties give so-called substantive standards of protection. That is, a state obliges itself under international law to do two things. First, to not treat foreign investors any worse than it does domestic investors. There's a general rule of non-discrimination. This is both the most important and the least controversial rule. It stands to reason that you should not, for obvious reasons, treat foreign investors any worse than you do domestic investors. Historically, of course, a rule of non-discrimination does not help you much in cases of big revolutions and expropriations. Because if, say, Iran decides to nationalize the entire industry, a rule of non-discrimination will not help you much. And so there are so-called absolute standards of protection. These are standards of protection that apply only to foreign investors. Traditionally, the most important is, of course, the one about no expropriation without compensation. It is generally accepted in international law that it's perfectly all right to expropriate for public purpose property of private investors. But what is not accepted in international law is that you can do so without compensating at fair market terms. The most controversial of all is the rule about fair and equitable treatment. It's controversial because its meaning is completely open-ended. This used to mean something like you should not kill or beat up people. What it now has become is a norm that imposes on states regulatory stability. That is, you should not defeat the legitimate expectations that foreign investors have about the regulatory framework of the state they invest in. ISDS proper only sees to the second aspect of it, and which is a procedural right given to foreign investors. It's absolutely unique in international law, but in this particular case, a private person, a foreign investor, can go directly to an arbitration tribunal and bring a claim against a state. What normally would have to happen is that an investor convinces its home state to exercise its powers under international law to resolve a dispute, but in ISDS, a private investor can claim directly against the state before an international arbitration tribunal, which operates under various rules and various organizations, but most importantly under an organization attached to the World Bank called ICSID, the International Center for the Settlement of Investment Disputes. So, a little facts and figures. This is the rise in investment treaties. The only thing you need to take away from this is that after the end of the Cold War, let's call it like this, in the 1990s you saw this enormous explosion of the signing of investment treaties around the world. The black line you see is the cumulative line, and so you see that we have now by far more than 3,000 bilateral investment treaties in this world. With an appropriate lag of 10 years or so, you can also see that the litigation rates under these treaties have exploded, whereas in the early 90s there were still just a very few cases internationally of investors against states. This has exponentially grown over the last decades, and so we are now over, well, it's something like 50 cases per year. So, just to worry you a bit, you have loads of them. There are 56 bilateral investment treaties signed by Hungary. A lot of them are with what are now fellow member states of the European Union, including with France, Germany, and the UK. It is more or less accepted generally, and it is pointed out by the European Commission time and again, bilateral investment treaties between member states are incompatible with EU law, and so they should not be considered in force. Hungary also has bilateral investment treaties with third countries, including Canada, China, India, Indonesia, Korea, Malaysia, Russia, Singapore, Turkey, and Vietnam. These are valid. They are protected by the EU treaty. And so obligations that Hungary has under international law, under treaties that it had signed before entering the European Union, are valid, and the obligations are still hold. Hungary is also part of the Energy Charter Treaty, which is a treaty signed by the EU itself, its member states, and countries to the east, on especially oil. So, partly because of this issue I told you about, that is, we have investment treaties between member states. They are in tension, at least, with EU law. It has been decided in the Lisbon Treaty to move foreign direct investments to the common commercial policy, which in theory would give the Commission the competence to negotiate these treaties and to bring foreign direct investment under the exclusive competence of the European Union. This is an issue that the Commission seems to insist on, but it's, well, controversial at least. Not least because the German Constitutional Court, in its opinion on the Lisbon Treaty, explicitly excluded the idea that it could involve so-called portfolio investments, that is, investments that are made not to achieve control of an enterprise, but just for financial reasons, minority shareholdings, for example. Okay, the EU has been negotiating these things with Singapore, done, Canada, done, at least the texts are ready, and now with the US. The Commission is apparently asking for an opinion on the issue of competence regarding the Singapore Treaty. That is, it is asking whether the Union has exclusive competence to sign this treaty. If the court says yes, then the Commission could try to argue that member states should not be involved in the ratification of TTIP at all. This is very unlikely to happen, first of all because various Commission officials and various national governments have made political commitments that member states will have to ratify this. And B, as far as ISDS is concerned, this would be an obvious tension with the legal framework inside the EU about ISDS. There is a so-called financial responsibility regulation which divides the responsibility for eventual claims under ISDS. That is, if a claim is brought for something that the EU is responsible for, an EU piece of legislation, then the EU will have to pay. If it is the member state that has done something awful against a US investor, then the member state will have to pay. And so obviously implicit in that is the reasoning that member states have responsibilities under ISDS apart from EU law, which means they would have to be involved in the ratification of that treaty. Okay, so why would we need such an odd system? And remember, I'll try and be as dramatic as I can, this is a private enterprise that brings a case directly under international law to an arbitration tribunal for a breach of standards under international law. It does not, the investor does not have to go through local courts. It can completely bypass the local legal system, the local political system, and it can ask for determination under international law for damages against that state. Why would we need it with the United States? Well, some say, but less and less people, that it will actually increase investment. Remember, there is $3 trillion of foreign direct investment stock across the Atlantic. That's $3 trillion that is not deterred by the lack of investment protection. If you want to argue that ISDS will lead to more investments, you have to argue that there are investors on either side of the Atlantic who are considering investing at the other side of the Atlantic, but are deterred from doing so because there is no ISDS treaty. It is nonsense. ISDS will not lead to a single euro of extra investment. The other one is, well, poor investors, they go there to the wild, wild west, or the wild south in Mississippi, and things are really scary there, and so we need to protect them against discriminatory and arbitrary behavior. No, these are perfectly legitimate legal systems. They're very developed legal systems on both sides of the Atlantic. And B, why should we protect foreign investors from these things and not, say, workers or whatever? The more fundamental arguments could be that most of Central and Eastern European member states of the Union, but not Hungary, have already bilateral investment treaties with the US. It covers less than 1% of FDI stock across the Atlantic, but Bulgaria, Croatia, the Czech Republic, Estonia, Lithuania, Latvia, Poland, Romania, and Slovenia have already bilateral treaties with the US. These are old-fashioned investment treaties, and you could make the argument that the EU needs to exercise its competence to write this new treaty so that these old treaties will be superseded and we'll have a brand new system of investment protection. The other one is that this will provide a template for global investment law, which is odd, of course, because the two richest blocs in the world should not even want to legislate for the rest of the world. Investment treaty law hurts most of all developing countries, and so the idea that the US and the EU will legislate for the world is morally reprehensible and not very credible. Another argument could be it will make it easier to negotiate later with the elephant in the room, which is called China. This is a strange argument as well, because remember, China is a very wealthy country. It has lots of money to invest in other countries, and China has more interest in investment protection than anyone else. Now, why am I and other people worried about this system? First, I'm not sure if you know how arbitration works generally, but this is what happens. I want to bring a case against a state. Then I appoint my arbitrator. The state appoints its arbitrator. These are party-appointed judges. Then we need a third, because the score is 1-1 to start with. And so we need to think of a president. The president is either appointed by agreement between the parties, or rather between the law firms representing the parties, or he will be appointed by a so-called appointing authority, which is generally the Secretary General of ICSID, that is, that organization attached to the World Bank. These arbitration tribunals work behind closed doors, more or less, even if there are strong efforts to increase transparency. These arbitrators, some of them do this for a living, some of them have a daytime job, which is to be a lawyer in a great law firm. Some of them act as counsel one day and as arbitrator the other day. There are rules on conflicts of interest which are not very strong. And so it is a system of private justice. Remember, the ethos of arbitration is we settle a dispute between two parties. It's a service rendered to the parties. The idea of arbitration is not to have effects on third parties. But in investment law, they have to be aware of the fact that they are dealing with issues of public interest, of sovereignty, of the right to regulate, and they impinge on very fundamental issues of constitutional importance. And so there's a big difference between a commercial arbitration between two parties, two pairs, and arbitration between a state and a private investor. Second, normally under rules of corporate separation and identity, it is the company that sues a state, but not the shareholders of the company. Shareholders have rights vis-à-vis the company. Shareholders do not have rights vis-à-vis authorities that act against their company. Under investment law, any claim to money, any share, any loan to an enterprise, any bond is considered a covered investment. And so every minority shareholder, however tiny his shareholding is, any foreign investor, foreign shareholder in, say, a Hungarian company, has the right directly to bring a case against Hungary for the way that Hungary treats that company. This means that the idea of investment law being applicable to foreign investors has to be taken with many grains of salt. Investment law will apply to every single domestic company as a foreign shareholder. Now, if you think of the level of financial integration between the US and the EU, you can easily figure out how many companies will not be able to bring a case under ISDS. That is very few. And this will lead to issues of discrimination. That is, some investors, even if they're not under EU law considered foreign investors, some investors will have the right to bring cases and some will not. Some will be able to recoup damages and some will not. 2. 3. There's an issue about the so-called autonomy of EU law. You may have heard of the ECJ's decision not to allow the accession of the European Union to the European Convention on Human Rights. It did so because, well, it's a decision that is deplorable, but it did so on grounds that the jurisdiction of the European Court of Human Rights could impinge on the exclusive right of the ECJ to interpret and to judge on the validity of EU law. It's not very likely that the Court of Justice of the European Union would be happy with a system whereby investment tribunals have the right to determine the compatibility of EU law with international law without it being able to exercise any control over this system. Last point would be on the effectiveness of EU law. And the easiest way to explain this problem is about state aid. You may have heard of the wonderful Mikula case. Maybe you haven't. I'll try and tell it as briefly as I can. These are two Romanian brothers who received subsidies from Romania. You wonder, how can they bring a case under ISDS? Well, they could because they suddenly turned out to be a Swedish company and there is a bilateral investment treaty between Sweden and Romania. Romania, under pressure from the European Commission, withdrew the subsidies. The Mikula brothers brought a case against Romania under investment law, arguing, look, we invested in Romania based on your subsidy system. We have legitimate expectations that you maintain that subsidy system. Now you have withdrawn them. That is not fair. They win. At that point, Romania has to pay damages to the Mikula brothers. Romania does this. It actually pays. At which point the European Commission gets very upset and the European Commission starts a state aid investigation. And they have come back last week saying, no, sorry, you lovely people of Romania, you have it all wrong. The damages that you paid in executing the award under investment law is in itself state aid. It is a selective advantage brought to one company and not the other one, and you're not allowed to do this. And so now Romania is obliged under EU law to recover the damages that it had paid to the Mikula brothers. At which point, of course, there's nothing to stop the Mikula brothers from bringing another case under investment law. And this can go on and on and on. That is to say, the European Commission's efforts to bring about an undistorted market are being thwarted, not by a decision on the validity of the decision of the European Commission, but by there being two parallel systems, and they shall not meet. There is not a way of figuring out a hierarchical relationship between investment law and EU law. And as long as that is the case, it is impossible to avoid investment law undermining the effectiveness of European law. I've talked for too long, I think, have I?
Yes.
Well, thank you.
Thank you very much. This was really exhaustive, and thank you very much for this detailed presentation. I've learned recently that with regards to ISDS and when we talk about the legal framework, there is no point about discussing how many cases were won by EU companies against the USA. There is no point discussing about how many cases were won vice versa, because it is not the matter of pragmatic numbers, it is a matter of principle. It's a matter of power of shift of power. It is a matter of our institutional setup. So this was the field where we were at the moment, and now we are going to another field where actually pragmatic numbers do matter, because we have a debate going on in the last 2 years around the economic consequences that we would have if this treaty came into force. And the original assessments and the first assessments conducted by the Commission were actually quite pro and quite positive about the effects of a TTIP agreement. And then after 1 year, we learned that there are criticisms and there are critical experts and critical schools which came up with other results. And this led us to a methodological debate around this whole issue, which is quite difficult to understand, but perhaps Professor Werner Raza from the Austrian Foundation for Development Research is going to be able to explain what's the point around this methodological debate, and also, which is interests me the most, the social cost of the TTIP, which is very rarely discussed in the public debate. And then, just to balance out, we are going to have 2 professors from Hungarian universities who are invited to have their contributions to the debate, so we are going to have a very lively debate.
Thank you very much for the invitation. It's a pleasure to be here and to contribute to this debate on the Transatlantic Trade and Investment Partnership. My name is Werner Raza. I'm the director of ÖFSE, which is Austrian Foundation for Development Research, a non-partisan think tank in Vienna, which does research on development issues from a political point of view, but also is working on the global economy and economic issues. Just to give you a short introduction into what we are talking about, a trade agreement which is very comprehensive, which has become to some extent clear already by the presentation by Professor Schepel. It is comprehensive in the sense that it doesn't only cover trade in industrial or manufactured products or trade in agriculture, but also it touches upon many other issues like services, investment protection, public procurement, intellectual property right. It touches upon a host of regulatory issues on which I will speak later in more detail. So it is a very broad agenda, and it is therefore, TTIP is therefore also called as an agreement of a new generation of trade agreements which aim at what economists typically call deep integration. That is a very comprehensive integration of different economic areas. So obviously what is at stake here in terms of the aims of the agreement is the creation of an integrated transatlantic market. And in addition to that, one of the central mechanisms to achieve this deals with regulatory harmonization or alignment of different regulatory systems. That is commonly referred to as cutting red tape. In itself, that sounds like being a good idea. Cutting red tape means making business cheaper, less burdensome for companies. But obviously, it involves a host of regulatory issues that are from a public policy perspective, sensitive and need to be dealt with very carefully. And one other reason why this agreement is so important is that it is to be understood as part of a geopolitical environment which has been changing over the last couple of years. So what we've seen is that the hegemony of the United States has been eroding, that the BRICS, in particular China, have become more powerful both in political and economic terms. So the US administration, for example, very explicitly states that TTIP, as well as the TPP, the Trans-Pacific Trade Agreement, between the United States and a number of Asian countries, with the notable exception of China, is an agenda that tries to re-establish and ascertain the political and economic dominance of the United States and Europe as its principal ally. So we are, and the means to achieve that is to aim at global standard setting via these two agreements, because that will then increase pressure upon the BRICS countries to speed up trade and investment liberalization, and infer a cost upon the BRICS countries if they remain outside these new evolving so-called gold standards of international trade. So these are the political and economic conditions under which these negotiations have been unfolding since 2013. Just to give you a very broad idea, I mean, obviously, we're not talking about two blocks, two economic regions that have not established economic contacts. And in fact, the United States and the US have a bilateral trade that is the largest trade volume between any two regions in the world. We now have something like 300 billion euro of EU exports to the United States and some 200 billion euro imports from the United States to the European Union, with the notable fact that the European Union typically has a trade surplus with the United States in the order of close to 100 billion euro, which is, from a macroeconomic point of view, quite notable, because this trade surplus has been more or less stable and increasing over the last 10 years. Very similar can be said about EU-US foreign direct investment. The bilateral stock of foreign direct investment between the two regions stands at above 3,000 billion euros, with annual FDI flows standing between 100 and 200 billion euros from either side. So also in terms of foreign direct investment, the two economic blocs are already to some significant degree integrated. And that means, obviously, we have a very high level of integration already, also without TTIP. My assessment of the economic effects of TTIP is basically based upon a report I have written with two colleagues from my organization and two American colleagues for the left party group in the European Parliament. And the aim of the report was to provide a detailed assessment of the projected benefits of TTIP by assessing 4 studies which were frequently cited in the public debate on TTIP, 2 of which were commissioned by the European Commission, the study by Ecoris from 2009 and the study by the Center for Economic Policy Research in 2013. And then you also included 2 other studies which were relevant for national debates, for the French debate and for the German debate. The latter debate particularly evolved around the study which was done by the IFO Institute and commissioned by the Bertelsmann Foundation. Okay, so what can we say when we look at these studies, which are, if you want, authoritative studies of the likely economic effects of TTIP, both for the United States and for the European Union? I don't have the time here to go into any methodological details, but just to give you a very broad overview of the economic effects that these 4 studies project. What we can see here is that the effect on income, on real income, as a percentage of GDP, will most likely be between 0.5 and 1%. So the most optimistic scenarios these studies assumed led them to conclude that there will be a one-time income effect for the EU economies, for EU consumers, if you want, of probably 0.5%. And this effect will materialize over a transition period of roughly 10 years. So you need to phase in the agreement, the different elements of the agreement. That will take some time. So this effect will not be a short-term effect. It will be a long-term effect. And it will be a one-time level effect. It will be an increase in the real income. It's not a growth effect per se. One has to be very careful about that. So the effect will be positive but small. Similar can be said for the United States. Also here, most projections estimate an effect below 1%. When you look at what will be the employment effects, there are some methodological differences between the four studies, but in general, one can say that there will be very moderate positive real wage effects if one believes those studies, and there might be positive employment effects, although that is questionable and very dependent on the assumptions you make on the clearing of the labor markets because of the trade shock that is going to happen. I'll talk about that in more detail in a minute. So, for example, the Schepel study, which has been the study commissioned by the European Commission, predicts that EU real wages will increase by something between 0.3 and 0.5%. Again, a very small effect. Other studies, in particular the Bertelsmann study, predicts the highest effect on unemployment in the so-called deep liberalization scenario, which is a scenario that assumes that the negotiations will be successful in substantially reducing both tariffs and non-tariff barriers to trade. In that deep liberalization scenario, something like 1.3 million jobs might be created, according to the study. Again, 1.3 million sounds large. It is below 1% of the EU labor force. And it will accrue only over a transition period of 10 years or more. Okay? So again, these absolute numbers might sound impressive, but in relative terms, they are rather modest. An interesting thing about all these projections is that they do not rely on a further reduction of tariffs to any considerable extent. Why? Well, because the average tariff rate between the United States and Europe is already below 3%. So any further economic gains from the reduction of those 3% will be minimal. So 80% of the figures I've just reported rely upon the reduction of so-called non-tariff barriers or non-tariff measures. And these, include a host of different regulations, technical standards, laws in sensitive areas like consumer protection or health and safety or environmental laws, etc. So we are talking here about a very broad set of laws, regulations and standards which are assumed in these studies to be substantially either reduced or aligned to a common standard. And upon these assumptions rest the assessments or the projections on the economic effects. The problem here is that methodologies to quantify the cost savings to companies because of the reduction or alignment of non-tariff measures are rather at an early stage. We do have in economic theory, I would say, no robust methodology yet on how to proceed with the quantification of such non-tariff measures. And this is, methodologically speaking, one of the weak points of all of those studies, although they entertain different methodological approaches to this question. For example, the ECORI study, which is the study where also the Schepel study relies upon, estimates that NTMs represent an average tariff cost equivalent to EU businesses exporting, for example, to the United States, of 17% of export value, which seems rather high given that other authoritative academic studies would suggest some 3%. So the assumptions which these studies we've looked at use in terms of quantifying the level of actionability of NTMs are rather bold. For example, in the EcoRisk case, the quantification depends on a specific survey design where more than 5,000 businesses in the European Union and the United States have been asked on their views of the restrictiveness of certain NTMs, and based upon these individual assessments, an index was constructed, which was then used to quantify the so-called tariff equivalent. And, well, you know, this can be criticized from a variety of perspectives, particularly that only, for example, business experts have been asked, and not other experts, say, from trade unions, consumer organizations, etc. So that is a very specific and crucial point in all the economic assessments. How do you really quantify the cost savings to companies of the reduction or alignment of non-tariff measures? And, you know, as of yet, no robust methodology is available for that. The second point to mention here is that implicitly all the studies assumed that, you know, while you should focus on the cost savings to companies of the alignment of non-tariff measures, this can be done so without any cost to society. Okay, so you have the cost savings, obviously, which is good for companies, and insofar as the companies then also reduce the final consumer price, is also good for consumers because the products become cheaper. Well, you know, regulations, say health and safety regulations, also serve a public purpose. So they are welfare enhancing. So if you change these regulations via the agreement, the trade agreement, by, you know, agreeing upon a common harmonized standard or by some other measure, there is a certain danger that because of the change also the social benefit of that regulation might be negatively affected. So you must not only look at the cost saving side to companies if you change regulations, so-called non-tariff measures, but you also must look on the effects of that change to society. And that's what I call the social costs of regulatory change. And this has not been done in the studies. Nobody has looked upon these potential social costs of regulatory change to societies. Well, you know, there might be good methodological reasons not to do that, because it's quite difficult to kind of quantify, estimate the social benefits of regulation, and there's also, you know, a long tradition or long discussions within economics of how to properly do that. But nevertheless, I mean, if you look at the cost-saving side to companies, the social cost of regulatory change must also be addressed by these kinds of economic impact assessments. And the point here is TTIP and the economic benefits of TTIP, which these 4 studies report, depend crucially upon NTM reductions in sensitive sectors from a regulatory point of view, such as, for example, food and beverages, chemicals, pharmaceuticals, and cosmetics. In all of these areas, the studies assume that 50% of the existing regulations can be aligned. That's called the degree of actionability, and this is rather high. I mean, this is a very bold assumption, that 50% of all the regulations in these sectors can be aligned, for example, through harmonization. The history of transatlantic regulatory cooperation would suggest otherwise. When you look at the last 20 or 30 years of regulatory cooperation between the United States and Europe, you see very little progress, because in many areas, in particular in those sensitive areas, because the regulatory philosophies are quite different. again, these assumptions, which are used by the 4 scrutinized studies with regard to the social costs of regulatory change, are rather sweeping and not very realistic. Another point of cost that needs to be taken into account is the costs of the trade agreement to certain key macroeconomic indicators or variables. This is also called macroeconomic adjustment costs. Any trade agreement will lead to changes to public income, because obviously tariffs levied upon imports are public income. In many less developed countries, this is significant. In the case of the European Union, for example, it is not as significant in comparison, but nevertheless, tariff income is part of the EU budget. If you reduce, say, all remaining tariffs between levied upon US imports to Europe, that would mean a revenue loss of 2.5% of the EU budget. Eventually, that might be compensated for by increased tax income, say by increased production, which is then exported to the United States. But in the short run, 2.5% of the EU budget might be lost. The second point is, what about unemployment? What about the labor market effects? Okay? So typically the studies, most of the studies as are reported, assume that there will be no permanent change to the employment level because of the agreement. There might be short-term changes between sectors, because some sectors say, German cars and the German car industry might profit from TTIP by exporting more cars to the United States. So German companies might say hire more workers. While perhaps Italian or French car makers might not profit from TTIP and will have to lay off workers. Okay? So implicitly, the studies assume that although these short-term unemployment changes might happen, in the long run, all laid-off workers in France and Germany will get a new job. Or, either within the car industry, so they will commute, or they will migrate to Germany to get a new job there, or they might get some other job. And they also implicitly assume that the new job pays the same wage as the old job. Both of these assumptions are probably not very realistic. We will have to be aware of that TTIP might lead to long-term unemployment. If you are a French worker in the car industry, 50 years or older, very unlikely that you get a new job that pays you the same wage as the old job. Also very unlikely that you'll be willing to migrate to Germany to get a new job in the car industry in Germany. So there will be some level of long-term unemployment. And that will lead, obviously, to social costs in terms of retraining expenses or unemployment benefits, etc. So, if you want to take that into account, you will come up with a certain cost to societies in the European Union, at least in the short to medium term, because of the sectoral changes in employment due to TTIP. We've done that in the study. We've provided a very rough calculation about the macroeconomic adjustment costs in the short to medium term, and we've come up with a number which is rather on the conservative side, between 30 and 60 billion euro adjustment costs, particularly because of unemployment and foregone public income from taxes and social security contributions because of the unemployed workforce. So these adjustment costs, again, do not look very big. 30 to 60 billion euro is not such a big number in absolute terms. Nevertheless, if you look at the policy instruments the European Union has for addressing the negative social effects of trade agreements or globalization, like the Globalization Adjustment Fund, they exceed by far the budget allocated to this mechanism so far. So some kind of policy response is needed here. Okay, what are other potentially negative effects? And you tell me if my time runs out. Well, obviously there might be some effects on third countries. Countries that are not a party to the agreement. Okay? Economists typically discuss that with two concepts, trade creation versus trade diversion. And very much depends upon which of these two effects prevails. So if the EU and the United States come up with this agreement, most of the studies we've scrutinized would suggest that there will be negative effects in terms of loss of exports for the rest of the world, in particular for least developed countries. So there might be a decline of income, real income, in Latin America and Sub-Saharan Africa in the order of 2 to 3% of GDP because of the agreement. Okay? Other studies refute that and say, well, that very much depends whether the agreement will come up with global harmonized standards or not. Because if the agreement comes up with, say, a new standard on food imports, hygienic standards on food imports, that will infer a cost saving to the rest of the world exporters. Because, you know, if you're a South African dairy producer and you want to export your dairy products to the United States and to Europe, now you have to comply with two different sets of hygienic regulations. Okay? If the United States and the EU harmonize these standards, the South African exporter only has to comply with one standard, yeah? With his exports. So that's a cost saving to him. That makes his exports cheaper. That means his export share will increase. So if that happens, and that's called spillover effects, trade creation might be an outcome of the agreement. If this kind of harmonization does not happen to a large extent, trade diversion effects, where the South African exporters or South American exporters are substituted by US products or EU products, these trade diversion effects might prevail. And if that happens, then we'll have negative effects on the income and exports of these third countries. So this is, you know, quite controversial. There's a new study now out by IFO, commissioned by the German Ministry of Development Cooperation, which also argues that there might be negative effects, but, you know, if you come up with policy measures and giving special trade privileges to less developed countries, these special privileges might then compensate for the negative economic effect. But anyway, again, a policy response is necessary here. What about the effect of the agreement on intra-EU trade, on trade between European countries? Again, most of the studies assume that there will be negative effects because intra-EU trade will be substituted by, say, US imports. So if you are a Polish meat producer, your exports to other European countries will now, or will possibly, compete with US imports of meat. Okay? And insofar as your product is not competitive with the US imports, your exports will suffer. And again, this is, you know, very, very specific on the assumptions which you make, but on general, I think it is plausible to assume that there will be a negative effect on intra-EU trade because of TTIP. But that, again, depends very much on the assumptions you make and whether, for example, US agricultural products will profit from the agreement or not. What about investment protection? Professor Schepel already made a very detailed statement. I just want to add one particular argument, not a legal argument, but an argument which comes from political economy. Okay? If, say, ISDS becomes part of the agreement, that will give transnational corporations, foreign investors, a second option to threat and a means to increase threats towards governments in the EU or the United States by referring to use that second option. So it will have an influence on the bargaining power of transnational corporations vis-à-vis governments. Okay? And we've seen indications, and there are specific cases, in particular with reference to the NAFTA agreement, where this regulatory chill effect has led governments to either refrain from introducing regulation that potentially would be subject to challenges by governments, or to water them by corporations, or to water those regulatory proposals down and to strike a deal with the private investors so as to preclude any challenge before such a tribunal. And it is no coincidence that in particular foreign investors from the United States and the European Union are the most active investors in resorting to these private tribunals. So certainly that kind of chill effect will have to be dealt with. And if a EU government is found guilty, so to say, under a tribunal using regulation that potentially would be subject to challenges by governments, or to water them by corporations.